Yes, sir. You are unmuted, sir.
Am I properly audible and visible?
Yes, yes. You're audible and visible, sir.
Thank you. Let me know when to start.
Sure, sir. Pallab Sisodiya, sir. Pallab Sisodiya, sir. Pallab Sisodiya, sir. You have joined from two devices, sir.
Yes, I again joined. There was some message that it's being updated.
Okay. Can I mute the other one, sir?
Yes. Can I start or have to wait?
Yes, sir. We can start, sir. If you
Okay.
can put your phone in a landscape mode, sir.
Landscape mode.
Yes, sir.
How is that done?
Just have to turn your phone.
Acha, okay, like this. Is it okay now?
No, sir.
No,
This is good, sir.
this is good.
Yes, we can start, sir.
Okay. Hello, everyone. All the dear friends at the bar. It's really a pleasure to be among you for this lecture today. And my pleasure is not customary, but a joy of sharing something which we lawyers practice every day, consciously and subconsciously. and to articulate thoughts on advocacy, and which you have to practice every day, and the challenges of professional ethics, which you meet on and off. It's a pleasure indeed. Let me begin by reminding you that this paper of yours is a very unique paper where even the examiners like me can fail. So be very careful and read widely on this subject, because, and it's very difficult to give you a outline of the study material, which is fairly diffused. Yet, every aspect of this paper is very important in your day-to-day practice. And mastery in advocacy is a lifelong pursuit. Even today, there are times when, after the matter is over, you keep on thinking that I would have put, if I had put this point in this particular way or that particular way, the outcome might have been different, or perhaps the court would have been more satisfied, etc. Now, this kind of a lecture is also look forward. People look forward to find some tips as to the questions which may be coming. Now, maybe you get some tips, maybe you don't get, but the best tip I would give very explicitly is to be very spontaneous and be very truthful in your answers, because some of the questions would be, and like in the court, are unpredictable and test your tendency and your propensity about the advocacy as well as the professional ethics. Now, first of all, what is advocacy? To put it simply, it's an art of communication, and in present context, in our context, the communication with the court. This art you practice with dominant objective of advancing or espousing the cause of your client. At the same time, you are an officer of the court with duty to assist for the cause of justice. Now, this is a kind of a duality or something which gives the impression of some kind of an apparent conflict. Now, this creates a very tension, according to me, a very healthy tension. And to navigate this tension and walk successfully on the tightrope of your dual duty towards client and towards the court, and also the opponent, is the advocacy we need to master. There are many do's and don'ts about and the tips to share. But first, again, I must share one more disclaimer that do not apply any of the tips blindly. For instance, your duty to advance the cause of your client does not mean that you tell a lie in favor of your client, nor the duty as officer of the court mean that you start arguing the weak points of your case in the court. So, all this has to be applied. Whatever we discuss about advocacy and the famous 7 gems of advocacy, etc., they must be applied judiciously and with a conscious thought. Now, we are conditioned to think that good advocacy means a kind of a flair in the speech, aggression in the court, and the passion to sway the opponent and the court in our favor. And the 7 gems of advocacy are really important. And this may also be true most of the time. But today, I would like to discuss another aspect of the advocacy, which is somewhat contrary to general notion. So I would like to discuss for your reflection as part of good advocacy, when, how, and what not to argue. Now, this is in contrast to normal belief that advocacy is always about something full of force, flourish, and fluff. I would like to highlight that listening consciously, observing mindfully, and openness to think on your feet is equally good part of advocacy. If I can repeat, listening consciously, both your opponent in the court, observing mindfully as to the what we call the body language, the facial expressions, and openness to think. And I'll elaborate that what kind of openness to think we need on your feet in the court is also a good part of advocacy. Now, in my junior days, I used to be very certain, most certain about the position of law, the attitude of judges, and the possible outcome in a given case in the court. Now, this certainty you lose as you grow, because the doubts and the ifs and buts come more as you go more mature in the profession. Now, armed with this kind of certainty, one goes to court with the most forceful argument. So much so that you get really obsessed to make the court hear you first, even before your opponent, and even in case when you are a respondent. Now, this is one of the tendencies which is observed, and in present days of aggressive advocacy, which is not like in the higher courts. This is very prevalent. So you like to get obsessed, and you like to make your point first, irrespective of the fact whether you are appearing for petitioner or respondent. Now, this kind of single-mindedness, apart from causing annoyance to the court, to the opponent, may lead to a situation where the court, which might be with you, may turn against you because you are highlighting a point without your knowing that you are highlighting a point which in the view of the court is against you. Now, if I can recall 2 of my own experiences in this regard. So on one occasion, I had a very poor case for the petitioner I was representing, and I was fumbling till the end how I would argue the matter, or how I would open my case for consideration of the judges. And in the court, before I could open my mouth, the other side started arguing very forcefully to highlight and very loudly to highlight the weaknesses of my case. And perhaps the judges disapproved, or they got disannoyed, or they were little confounded, or whatever the reason. They just inquired from me what the other side wants. And I politely informed the court that it appears that my opponent wants a notice to give a detailed reply for against me, against my case, against my petition. And with a smile, judges issued notice in a matter without my uttering a word on merit, about which I had many doubts. And I'm still wondering whether the notice was issued because of the bad manners of my opponent in the matter, or the merit in my case, which judges saw and which I could not see. Now, this is one example where speaking out of turn sometimes it becomes a example of a bad advocacy. Now, on another occasion, I was appearing in an application for vacating the ex parte interim order. Now, the client I represented was seeking to be impleaded, but his locus was very contested and very debatable. And again, this time, before I could explain why I should be impleaded, the other side lawyer jumped up and in his super anxiety started arguing that why I should not even be heard, my client should not be impleaded. Now, in the process, judges started asking some questions on merit, and they realized that the ex parte notice and the stay itself was issued on some wrong impression they got in the matter on the earlier occasion. And without my being called upon to address on merit, the matter was dismissed. And so there was no need for the stay to be vacated thereafter, because the matter itself was dismissed. Now, these are the instances where you realize that not arguing is also a good part of advocacy sometimes. Now, there are also situations where a question which is coming from the court and you start thinking that the court is against you, or you are so full of your own submissions that you don't reflect on the question which is coming, and you are going in your own flow about what you want to argue and what according to you is the clinching point, and the question which is coming from the court is not really that important. Now, this is one of the cardinal mistakes you make when you don't listen to the court, or the concern the court has, or the point of view the court has, or the doubts the court may have, or a clarification the court wants, and ignoring all that, you just go on your own track. And this results in a situation where you leave the court dissatisfied about their perception of the merit in your matter. And in the process, you may just lose a good matter, or at least the good answer which you perhaps be having in the matter, you are not able to give to the court because you thought that the question of the court from the court is not that relevant, but your own point of view and your perception about the matter is more relevant. Now, these are the situations where not to argue a matter out of turn may emerge as a better wisdom. And you must always keep confidence that the court would hear you before the order is passed, and the good point of view of good point of your merit can always wait for its proper turn. Now, there are also times when you feel that one aspect of the matter is so fundamental and central to your matter that sometimes even after a good order or a notice or a stay, etc., you still would argue because you want to share your preparation in the matter, or you want to share your enthusiasm about the point of view. And sometimes it so happens is that what you consider is the great point is perhaps in the eyes of the court is a negative point against you. Now, therefore, and I remember that there have been occasions when, after a favorable order, I wanted to tell the court about some more aspects of the matter, and it led to a certain inquiry and ultimately a dismissal of the matter, where otherwise I would have got the matter at least admitted for further arguments. Now, at these are the occasions where you're getting or remaining obsessed with your point of view and refuse to take the hint or deflect to other point. Sometimes what happens is that you are arguing on a point which you think is the best point, but the court considers not to be such an important or a focal point in your matter, and it gives you a hint that either you move to the next point, or they give you a hint about some other point and the court wants to be addressed on that point. Now, you may remain so obsessed with your point that either you refuse to take the hint or deflect to the other point, which may have more merit in the understanding of the judges. And here comes the point of remaining open and thinking on your feet, because the situation where you remain rigid to your one point or a single point pony, as they call, instead of being open to what is coming from the court, or what aspect that is bothering the court, or what are the other concerns before you get the final relief. The court wants to be addressed on that, and you refuse to take hint. But if you take those hints and you give the satisfactory answer, which may perhaps be there in your matter, then you would really drive home the point properly and carry the court with you. So to carry the court with you with the openness and nimbleness is another aspect of good advocacy. Now, there are so many other things which are part of your curriculum, and like the 7 gems, like the so all those things you study and prepare your answers for the exams. But I would like that, apart from this exam and the paper and generally speaking, I would like that you introduce a bit of a Zen practice in your advocacy, to be mindful, to be present in the moment, and to be open and nimble on your feet in thinking and responses in the court. Now, I move to the other aspect of your paper, that is the professional ethics. And there are several points to ponder upon. And my colleague, Mr. Shikil Suri, is going to elaborate more on these points, apart from advocacy. Now, there are rules about advertisement. Now, our jurisprudence is premised on the system where you as lawyer do not identify with the cause of the client. And because you do advance and espouse the cause of the client, which is very distinct from identifying with the cause of the client. So you are supposed to keep a detachment, not identify with the cause of the client. And that's why we, unlike the American system, we do not permit a share in the fees or a lawyer espousing his own cause, because if you share the fees, you have the stake in the outcome, and you would not be doing your duty in a dispassionate and a detached manner, which an officer is court is supposed to do. So you acquire a stake in the outcome and the proceedings, and you yourself become a litigant instead of being a lawyer for the litigant. And that is where things like advertisement or the share in the professional fees or the uh, uh, your espousing your own cause, appearing in a case in which you are really a litigant. Suppose there's a property dispute in the family or things like that. All this is not permitted in our uh, judicial system, unlike the American system where sharing of the fees or the lawyers advertising or the lawyers in fact doing their own investigation, etc., is all at par. All are permitted practices. But we do not do that because, so now this basic idea you have to keep in mind when you think of the advertisements on website or otherwise, or when you think of uh, a lawyer appearing or you're appearing in a case where you are interested or you are sharing a fees, etc. The the other aspect of the professional ethics is about this. We are all living in an age of social media and the normal media, where the instant publicity is really very exciting and life-giving. Now, and there is a lot of media glare on litigation, on courts, on judges, and even the prominent litigants who end up in court. Now, it's very interesting and very tempting to see yourself on the TV screen uh, from time to time, and it can be satisfying also sometimes to be part of the public discourse. But as a lawyer, when you argue a matter for a client about going to media about that matter by way of TV appearances or leaking the contents of your arguments or making your arguments on in public in uh, or having your YouTube channels, etc. All this shifts the argument from court to outside, and also again mixes up your role as a lawyer for the client and officer for the court into one of a crusader or a propagandist on behalf of your client. And this is something which will affect your performance, which will affect perception of your matter in the court, because when you start debating outside, the the perception or reception of your matter in the court becomes different. And what matters is how it is received and perceived by the court. Then there are issues of lawyer-client privilege. Now, the the one of the fundamental uh, premise in our jurisprudence is that whatever is told by a client to a lawyer is a privileged communication. Now, I can give you another contrast that when I was traveling in China, I was told that if there is information given to a lawyer by a client, in say in a normal ordinary criminal case or some property dispute or whatever, uh, it is the duty of the lawyer to inform the state about that fact. Now imagine this kind of regime if we follow, we would not be able to discharge our duty properly. We would not be able to even command the confidence of the client, and this can lead to a complete chaos. So this lawyer client privilege or attorney privilege is something very, it's part of our Evidence Act and the new Evidence Act also. Uh, and sometimes it can also throw you into an ethical dilemma that somebody says that I have committed a crime and but you defend me. Now this is a dilemma which has several answers, but luckily I have practiced in only an appellate court, and I would always tell people that I would go by record, not what one says about the matter. And whatever is the evidence on record, on that basis, you argue the best possible case you think is good for your client. Now, of late, particularly after pandemic, we have this new system of virtual courts and also the e-filing. Now, all these new systems have also come with the new challenges. Now, today we are having this lecture virtually. I don't know the number, whatever is the number of people, it would have been perhaps not very feasible for all of you to come to court and have a physical lecture as it used to happen on the earlier occasions, because everybody now arranges affairs in a way that by virtual meetings, you'd be able to do more. You can immediately after this lecture, you can go for your client's meeting, a virtual meeting of the clients, or before this lecture also, you might have done virtual appearances or the meetings and save the time of commuting in the crowded roads of Delhi and getting stuck in traffic here and there. So this is a great opportunity, but still the virtual hearings require certain etiquettes, and particularly etiquette where you appear before the court with all seriousness and in a formal manner, both in appearance, with your dress, etc., and the surrounding uh, screen or the surrounding scenario of the room you are sitting in. Normally, you should be sitting in your office with your books around and with your formal clothes on, and must address the court with all the seriousness the court deserves. Now, likewise, there are now big challenges in e-filing, because e-filing can sometimes be preceded by you're not meeting the client, but getting the instructions also electronically, getting your wakalatnama also electronically. And sometimes there can be a gap between between you and your client, in the sense that you may not even know that how your client looks like, and the instructions sometimes are you may doubt that the instructions are actually coming from the client and not some imposter or somebody not really authorized. Now, so these are the challenges which are thrown by this new methods of or new modes of our practice in a virtual court and the e-filing. And we have to be vigilant, we have to be careful in using these new tools of technology so that uh, mischief is avoided. Now, the another emotive topic in this paper and in our day-to-day practice is of strike. I have been practicing in Supreme Court since 1989. In last 35, 36 years, I have never come across an occasion when strike was called by the Supreme Court Bar Association or the lawyers of the Supreme Court. So I have not seen a single day of strike in Supreme Court. And it is, it gives it gives you a sense of pride also that yes, we have uh, had contested situations on behalf of the bar. We had to approach the judges so many times for this problem or that problem, but not by way of strike. And there are uh, and this was in a city where at the level of high court and the trial courts, there used to be a lot of strikes once upon a time. Now they are also, uh, after the judgments of the Supreme Court in common cause and the VC Mishra and the other cases, the strikes are less, but still it is a emotive issue. And we have to reflect that do the means justify the ends? So now there are at times very powerful and forceful argument about the justness of the cause for the strike, say for establishing a bench for the convenience of the litigants, or there is some kind of a attack or a crime against a lawyer. And so there can be always a desire to give a justification, but ultimately who suffers is the larger litigation public. And howsoever is the great cause, the strike can't be the answer because the means can, cannot, the ends cannot justify the means. So the end or a noble cause would not justify the mean, that is the strike. And this is what you have to reflect, that this can become a self-defeating exercise. And the judgments of the court, and especially in VC Mishra's case, and after that, the courts have taken the power of disciplinary control insofar as the strike is concerned. Now, there's another emerging area of practice, that is mediation. Now, what is the role of a lawyer in case of a mediation is something you must understand by understanding what the mediation is and what is its relevance, particularly in Supreme Court, when the case may be at the fag end or at the last stages of its determination. So this mediation is now emerging as one of the foremost means of alternate dispute resolution mechanism. And here sometimes the as I jokingly say that the mediation system works against the interest of lawyers who want strife and litigation to thrive on. But at the same time, it is also one of the great peacemakers in our society, and especially when the outcome of mediation is such that not only the disputes are resolved, but the relationship between the parties, particularly in family matters uh, of property disputes or the matrimonial disputes, the relationship between the parties are repaired and they are able to go along in life in a more happy and a conciliated manner with each other. Now, this is a area where your role as a lawyer is very important. And now, uh, there is now a thinking that the fee structure also should be fixed in a manner that if a matter is resolved, the lawyers must get a good amount of fees and not only for one or two appearances which happened in the matter. Now, the fees is only one aspect of it, but when to really propose for a mediation, because it is only when the litigation fatigue is there or when the parties are ready to talk sense and come to walk a distance to meet the expectation of other side, only then you can start the mediation. What should be your role when the mediation is going? Because on the one hand, it's your duty to frankly advise the client what are the limitations of his case, what are the possibilities of his case, how much is a gamble, how much is a how much is uh, in the lap of future, what would come out, what may not come out, and what are the areas where they can really think of compromising to get along in life. So here in mediation also, as a lawyer, you would have a slightly different but an important role of advising, guiding, and putting good sense in your client. Now there's another area of we have now a lot of lady colleagues at the bar, and there's a mechanism for gender sensitization, which according to me is part of the broadly the, the professional ethics or the conduct we must follow. So now there is, so there are some do's and don'ts, and there's a brochure by Supreme Court Gender Sensitization Committee, and there's a mechanism which is evolved. You must all study that, even if it is not, may not be part of your curriculum, may not be part of your papers, but it is important so that we this so that we are our conduct is more sensitive and better to our lady colleagues at the bar. Now, with this, I would now request my colleague, Mr. Shekhar Shikil Suri, to take over and address you. And
Thank
after this, we'll have a small question answer session. If you have some questions, we will request, will entertain few questions. Shikil, please.
Thank you, sir. Thank you. Thank you for such a wonderful lecture for myself. Also, I'm sure everybody benefited a lot. This was in about 40 minutes. I think you summarized 45 years of your practice in 45 minutes. So I genuinely believe that all of us are very fortunate to be witnessing this lecture and being part of it. So from all of us, I think it was a real pleasure for these 40 minutes. So now just taking forward sir's elaboration on professional ethics and advocacy. Oh, before I start that, I also want to first compliment all of you for taking this step of taking this exam as an AOR. And I think it's a matter of great pride and responsibility that all of you have chosen to take this exam. Becoming an AOR is a matter of pride and a lot of responsibility as well. So I compliment you for taking this first step. And as we say, this first step will lead to the second step as well. So my good wishes to all of you in advance for that. So two aspects I want to very quickly touch, and I know sir has really covered a wide array of topics on both ethics and advocacy. And I would now like to just distill this into some sort of an outline for you as to how you would get answers to some of the issues which sir has raised. So my first suggestion to you would be to look at the notification, and I want to give you a step-by-step sort of suggestion on how you would want to prepare, because time really is a constraint. All of you are active practitioners, I'm assuming, and so time is really short. So my idea in the next 10 minutes is to give you a sense of how you would go about preparing for this. I think sir has covered the broad areas that we would like you to focus on, but where would you want to start looking for the answers for some of these issues which sir has raised? So first step, I think what you should do is look at the notification that is issued regarding the syllabus. So go through that in detail. I think if you look at the notification, you would find that we have covered broadly the topics that would be covered in the notification. So first step, read that notification, reread that notification so that you get a sense of what the universe is there as far as your syllabus, what you need to focus on. Second, Once you've done that, then you would be wanting to know what materials you can look at, what materials you can review. So on our Supreme Court's website, I think there are 3 or 4 excellent materials that are available for you to see by senior advocates, and I think by the learned attorney general as well. So you can cull out those materials, and those materials really give you some structure as to how you would want to approach preparing for this exam. So have a look at those materials that are available online. Third, I think my suggestion would be for you to look at the applicable statutory provisions. So, for example, any questions that come to you in the exam, you would, of course, I think this exam really requires you to pause, think, reflect on what would be, there is no real right answer as such, but what in your view would be the right answer. So pause, reflect, and think on what you think would be the right answer. And that would be guided, of course, guided by number one, these statutory provisions. So as far as the statutory provisions are concerned, I would suggest that you have the Advocates Act. You look at Chapter 5 of the Advocates Act, where the rights, privileges, and duties as far as the advocates are concerned in the entire statutory scheme is covered. So I would suggest that you become familiar with the Advocate Act, and specifically, if I have to distill down, because there's no time to read the entire act, but I would distill that down to section 35 to 44. Those 10 odd sections really cover, what the rights, privileges, and duties and the statutory scheme as far as the advocates are concerned. So it's important that you are familiar with that. Second, equally important is the Bar Council of India rules. That would be chapter 2 of part 6. And I would suggest you make notes on this. Chapter 2 of part 6 of the Bar Council of India rules. There are about 5 or 6 sections which really would cover the aspect of ethics. So section 1 covers the duty to the court. So this really just sort of correlate what I am pointing out with what you heard from Mr. Shishodia earlier on. So the aspects about advocacy which Mr. Shishodia presented to you really would fall within these 3 or 4 categories. One is the duty to the court. Second would be the duty to your client. Third would be the duty to the opponent. And fourth would be the duty to your colleagues. So the last part of Mr. Shishodia's address, plus the initial aspect where he spoke to you about the advocacy aspects. All of this, ultimately, you would be guided by section 1, which is duty to the court, section 2, duty to the client, section 3, which is duty to the opponent, and section 4, which is duty to your colleagues. So as far as these 4 aspects are concerned, once you look at this, you will realize that your advocacy has to be sort of, when you address a court or when you're presenting your case or even drafting, all of these items that have to be addressed. For example, your duty to the court involves you to being very fair to the court. For example, in our early years, we were always told that whenever you're presenting a judgment in favor of your client, always present the judgments that are against you as well. So you're always well served by being fair to the court, not only presenting the aspects that are in your favor, but also aspects that are against you. In fact, my personal suggestion would be to always highlight the aspects that are against you, because that helps you win the trust of the court, where you at upfront indicate to the courts that these are the points that are against me and these are the points that I need to meet for the court. So that immediately gets you the trust of the court, and then you address and meet each of the points. So that really would be your duty to the court, where you are being fair to the court, indicating the points in your favor and points against you, judgments in your favor, judgments against you. And also judgments, while reading out the judgments, one other aspect which we learned during our early days was, don't just read the relevant paragraphs which are in your favor. Read the entire judgment, even if there are portions which are against you. You should never skip that. I think that is a blunder. If one does that, that is not acceptable. So idea ultimately, what sir was also suggesting was, you have to be fair to the court. And I would take this a step further in helping you think about how you mold your advocacy skills, is to put yourself in the shoes of the learned judge. How would you like your court to be conducted? Imagine yourself to be a judge, and how would you like your court to be conducted? Whether you would like a court where people are speaking, lawyers are speaking over each other, or would you prefer a court where, as the tradition is, as the custom is, that one party, the petitioner or the plaintiff, starts and the respondent responds, and then, of course, the opportunity to rejoin? One. Second, would you like the judgments to be placed in part, partially? So idea being that you always think as of yourself, being putting yourself in the shoes of the judge, and how you would expect the lawyer to be addressing you. So I think once you do that, you get all the answers of what you need to do when you are in court. That, and second, it will also give you an answer of what you need to be doing when you're drafting a petition. So this topic of ethics is very interesting. When I was thinking about this, reflecting about this topic, I realized that this has an interplay with all the three other topics that are part of your exam: drafting, practice and procedure, and the leading cases. So, for example, in drafting, ethics has a very important role. I mean, you have to present the facts as they are and not distort the facts. As a very simple example, putting it very simply. Then in your practice and procedure, ethics has a role. Then leading cases is my next suggestion to you when you're answering your cases or when you're thinking about some of the issues that we put forward. So one, of course, is, like I said, the statutory provisions one has to keep in mind. So that is the Advocates Act, the Bar Council of India rules, and also, let me complete that aspect, is in the Bar Council of India rules, there is a section 6, which is a duty to render legal aid. I think that also one must go through, and I cannot underscore the importance of rendering legal aid as legal professionals. I firmly believe that it is our duty, and this duty to provide legal aid is part of our larger sort of duty. When we talk about duties to the court, duties to the client, it also encompasses our duty to the society. When you're addressing the court, there is a duty to the court, duty to your client, duty to your opponents. There is a duty to the society, and this aspect of legal aid, I believe, is a very important aspect, and you must go through that. For many years, I had practiced in the US, and we don't have this here. But in the US, we always had this concept of a mandatory 50 hours of pro bono work we had to do every year. So that was a mandate under their local rules and regulations, and we don't have that here. But something for us to think about in the future, something I would also advocate for, that incorporate and inculcate this aspect of legal aid, providing legal aid to the clients that are the needy and the underprivileged. And the Supreme Court has an excellent legal services committee, which is a very vibrant and active legal services committee where matters from all over India come, and they have a panel of advocates on record. So I would very strongly encourage you to incorporate a provision of legal aid as part of your practice. And this panel also gives you an opportunity to work on matters ranging from civil, criminal, and working for the most downtrodden and the most underprivileged. And the satisfaction that one derives is not comparable to the other work. Sometimes, I mean, the commercial work is also important, but the satisfaction that one gets, because in most cases, you would not have met the client, your instructions would have come through a video conference, the client would be in jail or in custody, and you would be interacting with the client on video conference. So the satisfaction is also immense. So that is section 6 of the Bar Council of India rules. And then sir also spoke about restrictions on employment. That is section 7 of that Bar Council of India rules. The other aspect, which I'm sure you would have seen, is the Order 4 of Supreme Court Rules 2013, which speak about the responsibilities as an AOR. I don't need to emphasize more on that, but I would highly recommend that you go through Order 4 so that you're familiar with what the responsibilities, what are the additional responsibilities, not just as a lawyer or an advocate, but as an AOR, what would be your responsibilities? So one aspect while answering the questions, again, like I said, you would try and put your answers in these buckets of the statutory provisions. That's first. And this again is like advocacy, where how would you like to fit in your case? You would like to back your case by statutory provisions. So that's one. Second, you would look at the leading cases as far as professional ethics and advocacy are concerned. Then there again, there is a list that's available on the Supreme Court's website, which is I don't think it is exhaustive, but it is quite useful. I think it is updated till about a couple of years ago. So the last 2 years is what you need to add to it and review judgments as far as professional ethics are concerned and advocacy. So second aspect in answering your questions to cover is once you have the statutory provisions, then the leading cases or the judgments. Third aspect I would also encourage you to consider is, sir gave you examples of his experience in China and in the US. I've also had some experience of having worked and lived there. So some reading on what would be the comparative provisions as far as the regulations in the US or maybe one or two other countries will also help you in answering that question. So you can contrast maybe your answer with the provisions in the US. For example, one thing that just comes to mind immediately is sir spoke about advertisement. There are a number of restrictions that are there in our regulations, and I would encourage you to go through that so that you have a sense of what the restrictions are on advertisement on websites. But for example, in the US, there is this concept of contingency fees where the lawyers are paid depending on the success of the matter. So there is a very strong plaintiff's bar, as they call it in the US, where lawyers would undertake a matter and would be paid depending on the outcome of the matter. So if, for example, if they are successful, and if there is, let's say, a recovery of X amount, they would be paid a percentage of that amount. So question for you to consider would be, is this something which is permissible in India? If it is permissible in India, you could say why, why this is permissible, refer to the regulations, or if it's not permissible, refer to the regulation and contrast it with the US regulation. The second aspect that comes to mind is the concept of referral fee. Just taking this idea of contrasting. So in the US, if a lawyer would refer a matter, and I'm speaking broadly here, if a lawyer would refer a matter to another lawyer, in certain circumstances, he or she is able to charge a referral fee for referring the matter to another lawyer. Is that something which is permissible here? Not permissible here. Something for you to read and maybe again draw some contrast with other jurisdictions. So that would be the third aspect. So statutory provisions, cases, judgments, precedents, and third, if you are able to contrast with some other jurisdictions. I know, this would be difficult for all of us, given that we may not be very familiar. But some of these aspects one could look at, which are quite out there as to the differences between our system and the other systems. And the other aspect would be, while answering a particular question, if there are certain suggestions that one has, basis their experience, basis their own thought process, one should definitely, if time permits, also include what your suggestions would be for enhancing these concepts that are available to us. So that is, I think, as far as the structure is concerned, the reading material. Then as far as the reading material is concerned, I don't think there is anything that's out there other than 2 or 3 other papers, but there is one excellent book which I came across, which I would, with sir's permission, also suggest for you to have a look at. It's called The Professional Ethics for Lawyers. It is authored by another senior advocate from our court, Mr. Raju Ramachandran. He's authored a book on professional ethics for lawyers. I think the edition that I have is of 2014. But having looked at that, I do believe it would be very relevant, and it's a very concise book. It's about 150 odd pages, and if you look at the book, maybe we can try and take his permission for circulating this book also. I don't want to give you any assurances, but maybe if we can get permission from him, we could also share this with you. But if you do get your hands on that, it's an excellent book, about 150 pages. And what this does is it precisely gives you the history of professional ethics and the present dilemmas that are faced in. So this is of 2014, and like sir said, it's very interesting to know now. This is 2014, and now we are in 2025. So another thing for you to think, like sir mentioned, what are these dilemmas that one would face in our times? Our times, this concept of e-filing, this concept of video conferencing, these are the presence, the omnivorous presence of social media. These are, I think, ethical dilemmas which have come up in the last decade, or about last 5 or 10 years. So as you pause and think and reflect about these ethical dilemmas, you always see that every 10 years there is a new set of sort of ethical dilemmas that come up for which we need to think and address. So this book also has the relevant provisions called out. It has judgments of the Supreme Court on talking about the lawyer's role, some of the things that we discussed. It also talks about the lawyer's role as a mediator. Like sir indicated, it's a very interesting aspect about mediation. Now, there is, as you know, we have a recent enactment of the Mediation Act coming into the force, and we also see a lot of emphasis on mandatory provisions as far as mediation is concerned in family matters, matrimonial matters. So you would see, in your practice, you would have seen in the Supreme Court a number of matters getting referred to mediation, as sir pointed out. What could be your role as mediators, and within what parameters you would need to function as mediators, is what sir wants you to think and reflect upon. Because some of these issues that sir highlighted are issues that you would face on a day-to-day basis as soon as you start your practice as an advocate on record. Maybe you are probably practicing right now and having these some of these things, but as an advocate on record, there is that added sort of responsibility that comes on you. So things for you to reflect on. Piece, I think sir discussed, and also I discussed about this contingency fee, and also whether you can have a stake in litigation, we be able to represent clients while having stakes in litigation. All these questions which sir has sort of discussed. One tip from my side: if you look at the regulations, if you look at the provisions, a lot of these questions will get answered. Sir, I think that was about it. I just wanted to add one more thing for everybody. This exam, of course, is very important, and we are all preparing for it. And we are going to be looking at the provisions and the law and the other things. But one thing I would like everybody just is to think about, just a little outside the exam, is what is the place of ethics in advocacy. So think about this thing. What would be I would think that both ethics and advocacy merge at a certain level. So I would urge you to develop your own professional ethics compass, as I read somewhere. I read somewhere in one of the books that lawyers need to develop their own professional ethical compass. And that compass will help you answer not just the questions that will come in the exam, but also in your day to day practice, because these are questions that you face every minute, every day in and out. So develop your own professional ethical compass, and you will find that once you develop that, that it will give you your own identity. It will give you your own identity as a legal professional in court. Once you develop this and follow this, it will give you your own legal identity before the court, which will hold you in good stead. So with that, I hand it back to you, sir.
If I can uh, just share my reaction, or rather reflection, on 2 points. One is about developing your own ethical compass. So, there is one view that we are lawyers and we just represent a point of view, of course, in a fair and a straight manner, but without being a judge of that point of view. So, and that's why there is a rule that if some brief is offered to you, you may not agree with the client, you may not agree with his character, with his behavior, but it is your duty to represent his point of view without being a judge. Because it is ultimately the court which judges. Your ethical standards are in conduct of your duty. Your ethical standards are not being unfair to court, being very fair to court, being very truthful to court, at the same time doing your duty. Now, about the mediation, the duty, the question is not about what you would do as a mediator, because I must tell you one instance. I was appearing for a husband, and the court suggested the other side that you have a very fair opponent. Why don't you go and mediate with Mr. Shishodia? And I was little embarrassed, but the other side lawyer said, yes, yes, I have full faith, and they all came for mediation. Now, in course of mediation, there was we found out that there was a son between that contesting couple, and there was some discussion about the money which would go to that son in by way of some investments, etc. And I gave a little nudge to my client that the money is ultimately going to your son. Why don't you pay a little more? Now, what happened was very interesting. When the matter came next time, my brief was withdrawn. And so, the point is that when you are appearing as a counsel, when you are representing a party, you are engaged to remain an advocate. You're not there to be mediator. But even as an advocate, you have a role to advise your client, uh, to give him a reality check, and at the same time, don't not to sort of put a fear of God in his mind that he must settle at all costs and get rid of the matter. So these are the things which you keep on fine tuning, and the roles demand are very dynamic depending on the matter to matter and the stage at which that particular matter is. So with that, now we would open the floor for questions. If anybody has, we can entertain 10 questions for another 10-15 minutes. So let us know if there is any question from any of our colleagues. So it looks to be a happy situation that there are no questions.
Sir, I think the questions are in the chat box.
Okay.
I think just scanning through some of the questions, I think one common question which everybody has is what would be the pattern of the exam, and what would be the structure of the paper, and questions around that. I see a
We have already
plenty
given
of questions around.
sufficient tips. Shikil has explained the Supreme Court notification on the paper and the statutory provisions which you have to read, and study material, including the cases which are decided cases under the Advocates Act. Because, you know, the misconduct itself is not defined. It is evolved over the period by the decided cases. So, so the structure will be around that, and it's not something something like a big secret. What other question you can decipher, Shikil?
Um, Sir, these seem to be really the thrust of the questions. Um, one thing I mean, just add, sir, is that a lot of what is discussed here and a lot of what is what you would read as part of your reading, I would urge all of you to think and reflect on the issues that you have in your experience have faced, or some of the issues which have been outlined today. So think about sort of situations where you are asked to sort of answer. I mean, these are, I mean, as in an exam, also on a daily basis in your practice. So I think this exam requires a lot more of reflection and thinking as opposed to the others. So a lot of reflection would be needed on the provisions that you read, the judgments that you read, and how all of this would help you in answering the questions.
No, you see, there is a question about how many 10 marks, etc. So all that will you will come to know when you see the paper. But there's one interesting question that somebody said that if you can elaborate on media exposure and professional ethics. So I would like everybody to reflect on this that uh, trial by media in a mostly in the criminal cases or the sensational cases, it goes on a very different emotion, different consideration. And if you are party to it while being a lawyer and representing a litigant in the court, it would uh, sort of uh, come in conflict with your duty, because in court, the legal arguments, the way the facts are presented and appreciated, the legal arguments which are made, you can't expect that to be part of the public discourse in that manner, and a objective outcome coming out of it. So you immediately see a conflict between both the style and the imperatives of public discourse and the media trial and what transpires in the court. And that is why, if you are a lawyer in a given case, it is advisable, both in your interest and in the interest of your client, that you don't become part of the media debate on that matter or on that subject. And otherwise, you would be doing something in court and doing something else in media, and sometimes create a conflict, or sometimes, you can annoy the court by some public stand which may be justified in public if somebody else is taking. But if you are taking that stand in public and you are arguing something in court, it all, and we have seen it so many times, so many good cases. Ultimately, if you remember Hawala cases, the way they were played out in media, every politician was guilty, and every case fell in the court, even the trial could not begin. So this is where you have to understand this conflict between media and your duty as a lawyer, and the media exposure, etc. Any other question? You see, it's also difficult to Now, there's a last question here that explain the issues of advocacy in criminal law adversary system, the jealous advocacy in the. Now, I think I've alluded to this, that uh, I have seen in my life a lot of criminal lawyers who are very quiet and very undramatic, but at the same time extremely effective, because more than the flair in the court, it is the analysis of evidence, it is a coherence in your argument, and it is your mastery of the detail to pinprick the, or to negate the prosecution case. Now here again, after a point, all the advocacies are matters of personal style, personality of a given lawyer, etc. But the whatever style you adopt, what is more important is the thorough preparation and mastery of the facts and analysis and a very coherent presentation. Now, whether you do it in a loud voice because you are born with a loud voice, or whether you do it in a soft voice because you are born with a soft voice, it doesn't matter.
So on this, I'd just like to add, and you had alluded to this earlier. I think this question has come up a number of times in the chat. So, sir gave an example of criminal cases, and a simple example I'll just share with you. While doing a conviction matter, which was in appeal before the Supreme Court, sir, this was a conviction under 302. We had an interaction with the convict from jail, and the convict confessed to having committed the crime when we had that interaction with us. Now, question is, how would you react? Is that something which will affect your presentation of the case? So there are several aspects. Would it affect the presentation of your case? Is that information which would be privileged information which your client has shared with you and you are not supposed to share? So there are different facets of it. But as I would see in a criminal matter, and I can speak from a defense lawyer's perspective, having done a lot of matters for the convicts and the accused, is at this level, at the Supreme Court level, what really matters is an objective sort of examination of the evidence that is before the court. Because at this stage, when the matter is before the Supreme Court, what really is before the court is the records of the case. There is no further evidence that can be presented or anything, any additional facts or any additional sort of questions. So really, it's an objective assessment of the evidence on your part and presenting that within the contours of the provisions of law. So, for example, in 302 matters, essentially the matters that come up before our court are convictions by the trial court and by the high court. There are concurrent findings, there are findings on the evidence. And so what really you want to urge at the time of admission of the matter is really reappreciation of the evidence. So if you are able to make out a case for reappreciation of the evidence, will Supreme Court, interfere in criminal matters? Otherwise, generally they don't interfere. So at that point, once you cross that hurdle, your assessment of the evidence and then presenting the evidence in a manner where you can present the case to also at the same time address the aspects which you would want to put forth as a lawyer for an accused within the provisions of law, because our criminal sort of code also provides certain avenues where you can work within the provisions of the criminal code and still manage to get a relief for your clients. So I'm sort of taking the example where there's concurrent finding conviction, but within that also there are certain facets which you can examine and get some relief for your client. So your role strictly, you have to work with the provisions and try and see within those provisions of law, whether it is criminal or civil, you can sort of try and get relief for your client. So, not being an overzealous defense lawyer as well, or an overzealous prosecutor, and presenting the evidence to the court in a fair and objective manner.
There's another question about the difference between professional misconduct and the other misconduct. So professional misconduct is in a misconduct you commit in while acting as a lawyer in discharge of your professional duty. It may be towards the court, it may be towards your client, it may be towards uh, the way you sort of solicit work or uh, uh, share the fees without depending on the outcome, etc., or it may be with the opponent. Now, the other misconduct is not really while acting as advocate and interacting with court or the client or the opponent, but in, say, your misconduct in the bar association or your misconduct uh, as a senior sometime, if I can, sometimes, you can be unfair to your own chamber colleagues or whatever. So these are other misconducts which may not expose you to a punitive liability, but they are nonetheless misconduct, and all misconducts are bad, whether professional or the other misconduct. Then, yes. Now, there's another interesting point about one of the recent judgment of Supreme Court, where the Supreme Court has taken the view that we as lawyers are not liable before the Consumer Commission or in a consumer court. So a doctor who may be found guilty of professional negligence, which is very different from error of a professional judgment. So suppose a surgery which was not required according to one doctor and according to another doctor it was required. Now this may be a matter of error of judgment. Or suppose in a given case, whether you file a suit or a writ petition or some other proceeding, it may be a matter of debate, and you may make a choice of something which ultimately doesn't work. Now, this may still be a matter of error of professional judgment, but the professional negligence would be like a doctor not attending the patient after surgery at all, even though he's available and he's insisting for his fees, or a lawyer not going to court even though he's free and he's able to go, but he just doesn't attend. Now, the Supreme Court has taken the view that our profession is sui generis. It is in discharge of a very noble function, and unlike other profession, we are not liable for the professional negligence in the consumer court. Of course, action would lie before the bar council, or proceedings for misconduct would always be there, but not in the consumer court. Now, this has created a kind of a criticism that how are you different from a doctor? Because even for a patient, ultimately the God decides whether a particular treatment would work or not. Or so, like the argument that ultimately it is the judges who decide what should happen in a case, and the lawyer should not be held accountable in a consumer proceeding. So now this judgment, I would recommend everybody to read carefully and understand it, and this would have also help you in understanding what exactly is considered to be the nature of our profession in legal terms and what are the implications for it. I think we can there is a question about criticizing judiciary inside and outside the court. So there is nothing wrong in being critical of any judgment. There's nothing wrong in being critical of judges in their judicial conduct. You can write papers, you can speak up, but you have to be careful that you are not scandalizing them, you are not making baseless allegations, you are not being disrespectful, because ultimately we are all in the business of agreements, dealing with agreements and disagreements. And the Supreme Court judgments are very clear that to criticize Supreme Court is not a contempt, whether it is done by lawyers, whether it is done by public figures, and the judges most of the time are open to criticism, and they don't respond because it is not part of their function to respond to criticism, but they do definitely reflect if you make a valid criticism. So the criticism by itself is not bad, it is not contempt, but it depends how you do it. You must always be respectful, with restraint, and solid on the point, with a solid logic and research on the point you criticize about. About the foreign law firms, there is already a notification by Bar Council. You may accept it, but it's outside the purview of this paper. So, and generally, very generally speaking, I don't anticipate a good English lawyer or an American lawyer coming and addressing any of our courts. It has more to do with what we call the corporate practice and the work there, which where the lawyers, foreign lawyers, were always there indirectly at times. Yes, there is a question about the lien by advocate. So there are judgments of the Supreme Court, and which you will find in the compilation, that lien for your fees is not permissible, because the lien, your fees is a separate matter, and the trust which the client has initially reposed in you by entrusting papers or the originals of say some will or something, these are two separate things, and you can't assert a lien in a for your fees or for any other purpose. It's your duty to return the papers of your client. Now, the concept of moral turpitude is same as the moral turpitude for public figures. So these are all, the offenses in the BNS now about. So I think we have got sufficient number of thanks also now. So we can now wind up the so I think we can now, it's 90 minutes now, so we can conclude. What do you say, Shikil?
Yes, sir. I think I'm just looking at the questions. I think we've addressed almost all the questions.
People start saying thanks. It also means that
There's an
now they have
yes.
and we should take the hint. And we must say thanks to all our colleagues for being so patient and appreciating in the way the virtual lecture permits by a lot of thumbs up and etc. etc. So many thanks to all of you, and we wind up the lecture.
And we wish all of them good luck.
And all the good best wishes for everybody.
Thank you, sir.
खाली आ रहे हैं। ये रोक दो, मैं कर जाता हूँ यहीं पे। हाँ जैसे ओके सर, ठीक है।
मनमोहन मेहरा सर, क्या मीटिंग ओवर हो चुकी है सर?
भैया जी मेरे को कौन कॉल कर रहे हैं? आ जाओ। ठीक है।
मनमोहन सर,
हेलो।
सर मीटिंग ओवर हो चुकी है?
हाँ हाँ,
ओके, थैंक यू सर।
एक मिनट, आप कहाँ से कॉल कर रहे हैं?
नहीं नहीं, नहीं सर, मीटिंग ये जो लिंक चल रहा था ना सर, जहाँ से होस्ट हो रही थी मीटिंग, तो लीव मीटिंग कर दें सर? मीटिंग ओवर कर दें?
ऐसे कहती है कि एलसी की जरूरत नहीं है, डायरेक्ट। अच्छा, हाँ ठीक है, जब वो कह रही थी थोड़ा बहुत बंद कर दी ना सर। हाँ, बंद कर लो।